Hey, I want to welcome everybody, my students from Shawnee Mission East and anybody else who happens to be watching this video. Going to do a series of videos here on the Civil Liberties Unit in AP Government. Some of this is going to be review, some of it might be new to you, so let's get started. If we talk about civil liberties, the question that comes up a lot is, how do we balance this need for our liberty, for our freedoms versus civil order? And I think, if you look at anything that's going on in society right now, we have to have order, but should that come at the cost of giving up some of our liberties? Or do liberties matter more than social order? So as we go through this, that's kind of the recurring question that keeps coming up. In any of these cases that we look at, we try to balance that. And in American society, I think we do a good job of that as compared to some other countries. So let's get started on this. And we start with going back to what our civil liberties are. And I think whenever anybody thinks of civil liberties, they always think of the Bill of Rights. We have the first 10 amendments to the Constitution. And the part of this that's reviewed, remember, when the Constitution was written, the argument between the Federalists and the Anti-Federalists of, how strong a central government do we have? We need more order because obviously the Articles didn't work. But the Federalists said they're not really needed because the states are going to take care of that. And the Anti-Federalists said, no, we would love some guarantees in there. So as a compromise for the Anti-Federalists to vote for ratification, the Federalists promised, okay, first order of business when the new government starts is we will add a Bill of Rights to the Constitution. And that is what they did. So just quick review, starting with the First Amendment. The thing with the First Amendment, with religion, the two important clauses, the Establishment Clause and the Free Exercise Clause. And the First Amendment, talks about the fact that the government cannot establish a religion, which means they can't have an official religion, they can't make you worship a certain way or a certain religion. And then there's the Free Exercise Clause, nor prohibit the free exercise thereof. So you are free to worship as you please and do what you will in the name of your faith. And we've had several court cases dealing with religion, which we'll talk about a little bit later. But the idea is that none of these, as we go through, and you'll especially notice with religion, none of these rights or these liberties that we have are absolute. You can't say, well, I absolutely have the right to worship as I please because the First Amendment says I can. Well, that's not absolute because what if your religion practices the human sacrifice? We have other laws kind of against murder, so what's going to happen? So the ultimate decider of all of those questions will be the Supreme Court when they rule in cases. That's how we know. You can't say, well, hey, human sacrifice is my freedom of religion, so therefore I can do it. The court would say, no, you can't. So keep those in mind. None of these are absolute. Then there's speech. Obviously, again, not absolute. I think the one that comes to mind all the time is you can't yell fire in a crowded movie theater. You can't yell bomb on an airplane. Well, you could yell bomb on an airplane, but the rest of your flight is going to be miserable for you. So, you can't cause panic. You can't do those things in the name of free speech. Freedom of the press. The idea we have defamation laws. We have slander and libel. With the press, libel laws are those things that are written. A newspaper can print anything they want, but it doesn't mean that they can't pay the price later on. If it's libelous, if it damages somebody's reputation, they can get in trouble for that. But they're not prevented from printing it in the first place. But there might be legal repercussions, if it turns out not to be true and it damages somebody. To peacefully assemble, which means we can get together and criticize our government, whether that's back in the day, in the taverns where the colonists would get together and complain about the British government. What can we do? And which led to the American Revolution. British government didn't like that because they didn't like people talking bad about the government. So that became then an important one, is to be able to get together and discuss. And then there's a petition for redress of grievances, which means we have the ability, the right, the liberty to complain about our government and say, hey, we would like to see a change because we don't think you're living up to the expectations. So that's the First Amendment. And the Second Amendment, getting into this, the right, a well-regulated militia being necessary for the security of a free state. Okay, and that's that first part we forget. The right of the people to keep and bear arms will not be infringed. And so, yes, you have the right to a gun. We'll talk about the case later on. McDonald versus Chicago. The idea of does the Second Amendment mean you have the right to own a gun? And it does. But we also have to look at the intent of the Second Amendment, and you can't ignore it. I know people on the right will say, it says the right to bear arms. People on the left will say but it's only for a well-regulated militia. It's both, and so that balance that we try to strike with the Second Amendment kind of has to take both of those things into account. So we'll get more into that case as well. Third Amendment, according of soldiers, really not applicable because we have barracks. So let's move on to the Fourth Amendment, search and seizure. Now, this is the one, especially teaching a high school class, where I get the most questions. The police have to have a search warrant to search your home. So all the questions that come up, but upon probable cause and a search warrant issued, talking about the Fourth Amendment here, which also leads into privacy issues. The idea that they have to have a warrant, again, is not absolute. Do they have to have a warrant to search your house? Yeah, they do, but there are exceptions. If they hear a gunshot from inside the house, if they hear somebody cry help from inside the house, they can't enter the house, and they don't need a warrant for that because this imminent danger that we look at with all of these rights. But what about your car? Do they have to have a search warrant to search your car? And the answer is no. They have to have probable cause. They have to have a reason to search your car, but they can without a warrant. And obviously that should make sense to you guys. If I get pulled over and they see an empty beer can, or they smell weed, or anything like that they have reason to suspect that a crime is being committed or might be committed, and they leave to go get a search warrant, you're going to just drive off. I mean, so the idea that they have to have a warrant to search your car is not accurate. So that is one of those exceptions to all of these rules. The Fifth Amendment, man, there's a lot in the Fifth Amendment, and as we go through this, you're going to start to see a pattern develop with the Bill of Rights that most people I don't think are aware of. So once we get down to the end, I'll let you know what that is. The Fifth Amendment, right to a grand jury. Now, right to a grand jury just means that if you are accused of a serious crime, a year or more in jail, or a capital crime, death penalty, the state has to prove to a jury, a grand jury. This is not the jury you see in a courtroom. They have to prove there is at least enough evidence to go to trial. They don't want to waste people's time, money, just wrongful accusations. They have to show that there's at least enough evidence to warrant a trial. Now, they don't have to prove to a grand jury guilt or innocence. They don't, and the defense doesn't get a say in a grand jury, but the state does. And so they will convince a jury of your peers that we have enough, and here it is. Here's what we've got to go on. Then the jury trial starts, and that's when you see the 12 men up in the jury box and all that. That's not a grand jury. Grand jury comes first. There's double jeopardy. This one most people know because of the movie with Tommy Lee Jones. The whole premise of the movie was wrong. Ashley Judd's character. I'm sorry if they're fans of the movie Double Jeopardy out there, but there were so many elements of that movie that were not accurate. It just makes me cringe. That's why I can't watch movies that they take a real life thing like a jury trial or a battle in space like Star Wars, and they get it all wrong. It's just not okay. Anyway, double jeopardy means that you cannot be tried for the same crime twice. But again, if you are found guilty, that doesn't count. Double jeopardy doesn't play into account if you're found guilty because you're not being tried and you are going to appeal if you're the criminal, if you're the defense. That's not double jeopardy. What double jeopardy is if you're found not guilty and later on they find evidence that would prove your guilt, they cannot try you again. The famous case that everybody talks about is O.J. Simpson. Once O.J. Simpson was found not guilty, in a court of law by a jury of his peers of murder, he literally, I don't think it would be smart, but he could come out and say, yes, he could admit to the crime, and they couldn't try him again because of his Fifth Amendment right to be free from double jeopardy. Eminent domain, this idea that government can't just come and take your property without just compensation. They can take it, right, if they need to build a new school or build a bridge or, flood plains or, any of the stuff where they need to improve the quality of life or improve the service of government. They can take your property, but they have to pay you fair market value. So that's always important. Right to be free from self-incrimination. You do not have to testify against yourself in court. So if you, and by the way, I would never recommend, if you're being accused of a serious crime, always plead the fifth. That doesn't mean, well, he pled the fifth, so he must be guilty. That is ridiculous. No, the lawyers are smart. These attorneys are good, and they'll twist your words. They'll bring up something and make you seem maybe unsure, not necessarily guilty, but unsure and kind of twist your words or whatever. So always plead the fifth. It makes no sense not to if it's a serious crime. Now, if you want to fight a traffic ticket and you go to a judge and you invoke the fifth, that's just going to upset the judge. Don't do that. But in serious crimes, absolutely self-incrimination. You are free from that. So the Sixth Amendment, speedy and public trial, and assistance of counsel. One of the cases that we'll look at, we'll deal with the Sixth Amendment issue, but the idea of a speedy and public trial. Public makes sense. It has to be out in the open. They can't do it behind closed doors. But speedy, that has to be determined. Obviously, a speedy trial for a misdemeanor, for a traffic ticket, or something along those lines would be a matter of days or weeks, as opposed to murder, which may be a speedy trial. It may take up to a year or two for those cases. So the more serious the crime, usually the more time it takes. So speedy will be defined by the court. And then the Eighth Amendment, free from cruel and unusual punishment. They can't give you the death penalty for jaywalking. Obviously that would be ridiculous. So the pattern that we've been looking at, if we go back to to these, you think about the Fourth Amendment, search and seizure, Fifth Amendment, grand jury, all of these things have something in common, and that is they all deal with the government accusing people of crimes, and all the things that come along with this. If we're accused of a crime, trials and juries and all stuff, and they have to prove in the Eighth Amendment, cruel and unusual punishment post-trial. So most of the Bill of Rights deal around the rights of the accused, not necessarily speech and religion and all that like we think about, but rights of the accused, and rightly so. The Ninth Amendment, that's that catch-all. We talk about the elastic clause, in Article 1, Section 8, where anything else the government or the Congress deems necessary and proper. Well, this is similar to that. And the Ninth Amendment says, there's no way we could list everybody's rights, in the Bill of Rights. So this basically says, if it's not in there, doesn't mean you don't have it. So there are rights that are retained by the people that aren't listed here. Those rights are still there, even though they're not listed. So that's that catch-all. And then, of course, the 10th Amendment, we talked about this in Unit 1. When we wrote the Constitution, this is where the reserved powers are. Those things not listed here, given to the national government, are reserved for the states. So those are the things. Just if it's not there, it is reserved to the states. So hopefully, a little review on those. If you're still unsure about some of those, look these up. Obviously, throw me questions. You guys know how to get a hold of me. So looking at the definition of civil liberties, then what does it mean? The civil liberties basically are those basic rights and freedoms that we have, that were given by the Constitution or interpreted by the courts. But essentially what it's doing is it acts as a shield. It protects you against what the government do. The government cannot prevent you from worshiping as you please. The government cannot prevent you from speaking your mind. The government cannot prevent you from these things. So civil liberties are those things that you are protected. A lot of them are, even in the document itself. We think about the Bill of Rights, and that's where, most of them are. But understand, in the Constitution itself, before the Bill of Rights was ever added, there were civil liberties like habeas corpus, ex post facto laws. These things that, writ of attainder. Those things are in the actual document itself. Those were so important. If you think about those, habeas corpus, they can't just put you in jail without charging you with a crime. They can't. That's a right a right of the accused. Ex post facto, they cannot charge you with the crime if you committed the crime before it was illegal. So if they pass a law today that says you can't do that, they can't go back and say, well, you did it yesterday, so you're busted. Can't do that. So again, rights of the accused become very, very important with the government. So how does this then, match with civil rights? Civil rights are a little bit different. Civil rights are those things, the basic right to be free from unequal treatment because of something that you are or that you possess. For example, race. They can't say, well, men have these rights, women have these rights. They apply to everybody. They can't discriminate you based on gender. They cannot discriminate you against you based on a disability. The question about disabilities that come up, that's like, if can you get turned down for a job simply for being black? And the answer is absolutely not. Can you be turned down for a job just because you have a disability? Well, here it comes in, well, what does the disability mean? Can you do the job given your disability? And if you can't do the job given your disability, that's not discrimination. So that it wouldn't apply there. But because you're a woman, yes. Because you're black, because you're Latino, because you're Asian, yes. Those things absolutely would be against civil rights. So we'll get into a separate video on that. So the question becomes, what happens if my rights that I have maybe conflict with the rights that you have? And we have several examples of this. One of the ones we talked about earlier was the ACLU versus and the Nazis versus Skokie, Illinois. Fascinating case, and this was in 1977 in Illinois. Situation was there were some neo-Nazis that wanted to march, protesting the local government, whatever, and they were gonna have this march down the sidewalk, and the town said, absolutely not. You're a hate group. It's going to create violence, and the people in the town didn't want it, and so the Nazis sued. Went all the way to Supreme Court. Short answer to this is, can the Nazis march? And the Supreme Court said, yeah, they can. They have the freedom of speech to do that, and regardless of what you feel about what they're saying, they have the same rights to free speech as everybody else. So the town of Skokie ended up losing that case. And another similar case would be the Snyder versus Phelps. This is 2011, so this is a little bit more recent. And of course, being from Kansas, you gotta love the fact that anytime Kansas makes the national news, it's always something stupid. This happens to be one of those things. Sorry if I'm giving my opinion there, but this case of Snyder versus Phelps. We all in Kansas are familiar with Fred Phelps, founder of the Westboro Baptist Church in Topeka, Kansas. Now their whole thing is anti-homosexual, and so when they protest things, they'll have just signs that are just awful. God hates fags. We love dead soldiers. All of those things. And so Snyder was I believe he was a Marine, and he was killed in action. And they were having his funeral, and the Phelps family were protesting his funeral. Now, was the soldier gay? No, he was not. And their logic, the Phelps' logic was, since that soldier fought for the United States, and the United States accepts homosexuality, the United States must be bad, and so therefore we have to protest those people that protect it, and which makes no sense. And I'm guessing most people would get that, but don't send me hate emails. But I disagreed with the outcome of this case, and the Supreme Court basically said Phelps has a right to do that. Now, there can be some restrictions as far as how close they can get to a funeral, but just because you don't agree with what somebody says doesn't mean they don't have the right to say it. So as vile as what they preach is, and doesn't really match up with any main religion that I've ever seen as far as how you treat people, the Supreme Court said, hey, freedom of speech, and it works. Boy Scouts of America versus James Dale. This was 2000. And Mr. Dale he had been an Eagle Scout. He was an assistant scoutmaster. And basically they found out that he was openly gay. So they kicked him out of the Boy Scouts. He sued saying, hey, you can't discriminate based on sexual orientation. This was in New Jersey. And, went to the Supreme Court. And the Supreme Court basically ruled, the Boy Scouts it's a private organization. It's a religious organization. And their desire to keep, the Christian faith as they saw it, out of the Scouts was upheld. So they didn't have to let people that are gay be in the Boy Scouts. It's very similar to any private. So you remember we talked about civil liberties that protect you from the government. The Boy Scouts of America are not the government. Very similar thing with the person that baked a cake in Colorado and would not bake a cake for a gay couple, a wedding cake for a gay couple, and they sued, and the government came back and said, hey, it's a private business. They can choose, their own First Amendment, free exercise clause, if you remember that one. That is legal. So similar case with this. And then the Vernonia School District versus Acton. This is a drug testing case in a high school. So it was a high school, and basically there was rampant drug use, and they wanted to make it safe for athletes. And so they started random drug testing athletes. One of the kids refused to take the drug test. Looking back now, we could say it's because he was going to get tagged as having used drugs. So he refused the test, and they kicked him off the team. So he sued, saying that was a violation of his Fourth Amendment, search and seizure. And the court came back and said, no, given the nature of what schools are, and keeping kids safe, keeping athletes safe, as long as they're random, it doesn't abuse the Fourth Amendment, somebody's Fourth Amendment right to a search warrant. So as long as it's random. So those are some examples of how those can come into conflict. And as we go through, and as we have gone through these, the question of which side's right, which side is wrong. Is it the Nazis, or is it the town of Skokie? Is it Snyder, or is it Phelps? Who gets to make the determination? And it always comes down to the courts. And so the courts will make these decisions. As much as we may agree with one side or the other, it really is dependent upon the court to interpret the Constitution and say, Constitution, we interpret it this way, and so therefore we're ruling like this. One of the first cases dealing with civil liberties was Barron versus Baltimore. Very important case for you guys to know. And this is in 1833, so we're going way back on this one. And basically, this guy, he's in Baltimore, and he has a wharf. The dock ships will come up, and they unload their stuff, and they pay a fee to Barron for the use of his wharf. So he's getting very rich on this. Trade, sea trade, coming in 1830s. But they start doing street repairs in Baltimore, and as the silt, as the rain came down and washed dirt and silt into the harbor, it basically raised the floor of the harbor, and so ships could not dock on the wharf anymore. So Barron's like, okay, now what do I do? Well, I'm going to sue. So he says, I'm going to sue in state court, in civil court, because that's not right. You're taking away my money. If the ships can't get there, I can't make money, and therefore I'm going to sue. And so what we're looking at here then, of course, is this idea of eminent domain. And the Fifth Amendment, if you're talking about the Fifth Amendment, the takings clause, nor shall private property be taken for public use without just compensation. So eminent domain is what he is suing on, because Baltimore took his wharf, his private property from him. And this was all the way to the Supreme Court, and Chief Justice John Marshall, Superfed, if you remember that, he lost. It's like, sorry, guy. And the reason he lost is because if you read the Bill of Rights, they don't say anything about state governments, and therefore, the court couldn't apply this idea that, well, the Bill of Rights applies to, the city of Baltimore, the state of Maryland, only the federal government. So in 1833, the Bill of Rights only applied to the federal government, not the states. And so the example that we can look at is like, does the protective light of the Bill of Rights shine on me, my civil liberties, my protections against my state government? And the answer, because of Barron versus Baltimore, is no. They put there's this Barron versus Baltimore wall that we talk about. Because of that, if your state government, if your state constitution said, you have the right to freedom of speech or religion or eminent domain or any of those, then you would be protected against your state. If your state's constitution didn't say that, the federal government was like, sorry, man, this only applies to us. So this kind of set the precedent then for cases that come up. We are going to break this down. All right, this wall will eventually come down because of our next topic that we're going to talk about in the series will be a thing called selective incorporation, and I'll define that. We'll get into some more court cases and kind of show how this wall has been chipped away at. But until then, if you have any questions, you can get a hold of me, shoot those questions my way, and I will be happy to answer them. All right, take care, guys. Until next time.